Ms. McNeil, I believe we're going to start in just a moment with the one walk-in complaint.
Okay.
Just want him not to touch anything.
So see here, please just don't touch the computer. Yep.
All righty. Good afternoon, everyone. I'm going to call the matter of the state of Wisconsin versus Daniel A. Rice. It's 20 CM 736. Appearances, please.
The state appears by Carly McNeil.
All right. Thank you, sir. Are you Daniel A. Rice?
Yep.
Mr. Rice, did you get a copy of the criminal complaint?
Yes, I did.
Did you get a chance to read that criminal complaint, sir?
Yes, I did.
You understand the maximum penalties and what the charges are for in this matter?
Yes, sir.
All right. Court's also reviewed this complaint. I'm going to make a finding here that I find probable cause exists that the misdemeanor crimes as set forth in this complaint were committed and further probable cause to believe this defendant committed those crimes and therefore finds the matter over before the Honorable Bruce E. Schrader for further proceedings. But Mr. Rice, I'm going to enter not guilty pleas on your behalf to both of the counts contained here in the criminal complaint. We're going to set bond in a second here. I'm going to ask the state first what its position is, then I'll ask you what your position is as to bond. And we'll get you some court dates. Now, I understand you have $650 that you posted. Is that correct?
Yes.
All right. Also, you have every right to represent yourself in a criminal case, sir. However, I do not recommend that you or anyone else does that. Instead, I would recommend that you consider retaining or hiring your own counsel, or if contact the state public defender's office if you wish to see if you're eligible for representation through that office. Okay?
Yep.
All right, thank you. All right, now, Ms. McNeil, I've entered not guilty, please, on behalf of Mr. Rice as to bond.
The state would like to request continuation of the bond that is posted, and we are requesting the condition of no contact with Jenna Danowski or her residence. I will inform the court that Ms. Danowski contacted our office. She indicated that she is not available to appear today, but she expressed to us a wish to have contact with the defendant because of their kids, and said she did not wish for anything to happen with the defendant in terms of charges. We explained the process to her, and I do understand her wishes. But given the threat in the criminal complaint to Ms. Danowski, if she called the police, I do think a no contact order is appropriate. And so that is what the state is requesting.
All right, thank you. Mr. Rice, what are you requesting, or what would you request or respond to what the state said in terms of bond?
I mean, as far as the no contact.
You can tell me what you believe is proper and what you wish to have done in the bond.
Basically, like I said, I'm the one that watches the kids during the day. She works her job. I quit my job 2.5 years ago to watch our children. So we don't really have any other options. She's having to watch them right now. But basically that's already, she can't watch her on Monday because she has a cancer treatment, and she's kind of already assuming and hoping that I can watch them next week. Yeah, I don't know. I guess, like I said, this is very unfortunate circumstances. I can assure you there is no threat to Jenna, and I know she knows that too. And I mean, what happened was an isolated incident. And
don't say anything further, sir. You're presumed innocent, and I don't want you to say anything against your legal interest here. That everything's being recorded, could be used against you. Okay.
Yeah, I just, like I said, I just wanted to express how much, like, I'm the sole person that basically has taken care of my 2.5-year-old kids for the whole 2.5 years they've been alive. I mean, we really don't have another option to watch the kids. Daycare is not an option for her. I mean, we've taken the COVID. My son has respiratory issues, so I mean, this is all just really unfortunate.
Well, here's what I'm going to do, sir. Well, first off, I'm going to find that in this case and the remaining cases that are appearing today, before this court via the Zoom application, that good cause exists to hold these hearings via the Zoom application, again, based on the coronavirus pandemic, as well as the orders that have been entered by the Wisconsin State the Supreme Court, as well as the Circuit Court for Kenosha County. Sir, what I'm going to do here, I find that cash bond in this case is necessary to assure the defendant's appearance in court. It was posted and the defendants appeared, so I'm going to order a $650 cash bond. You've already posted it, so it won't be returned to you yet, but you also are not required to post any additional funds. The $650 cash will remain. Conditions of bond, though, sir, at this point, I'm going to allow third-party contact for the child care and children. A third party may pick up your child or deliver your child back to your wife, whatever. But for you, sir, I'm going to order no contact with Jenna M. Danowski. That means for you, no contact in person nor through any other means. The only contact is third-party contact. Now, let me ask you this too. Do you need to have removed from the house and given to you any personal effects, clothing, or medications? Okay, I'll allow a third party again to do that. I'll give you 24 hours to have that done from the point when you sign your bond here in just a minute. That you then have 24 hours following that to send a third party to the residence to collect your belongings, personal effects, clothing, medications. But you yourself, sir, may not. And again, it's no contact for you in any form, anytime, on any means. Do you understand?
Yes, sir.
Okay. And then also, you must appear in court when required and not commit further crimes while you're out on bond. Do you understand?
Yes, sir.
All right, great. Thank you, sir.
Your future court dates are going to be pre-trial conference with Judge Schrader is August the 6th at 9:50. And to go with that, Judge Schrader always has a jury selection date, which is August 24th at 9 o'clock.
That'll be written on your bond.
Just to be clear, there's no contact at all until after the court date, correct? Until after wherever.
As of right now, there's no contact. And
All right,
until if that's modified later, then that'll be up to another court. But for right now, is the bond conditions I've entered, no contact except the third party for the children and to collect your belongings.
Okay, thank you.
All right. You're welcome, sir. Mr. Grave, are you going to be appearing for Noah Phillips?
No.
I didn't think you were. That was the question, but it was answered, but your voice is different there.
I was going to tell Ms. McNeil that Mr. Phillips is first.
I figured that, I know. That's fine. I was. I will call the matter of the state of Wisconsin versus Noah M. Phillips, 20 CF 688. Appearances, please.
State appears by Carly McNeil.
Attorney Brett Copeland appears by video Zoom conference on behalf of Noah Phillips, who appears in court in person in custody. Your Honor, we do have a copy of the criminal complaint. Mr. Phillips is aware of the associated charges and maximum penalties. We waive a reading, reserve all pretrial motion issues and jury trial rights, and we would ask for a preliminary hearing.
All right, thank you. Request for preliminary hearing is noted and entered for the record. As to bond, Ms. McNeil?
The state is requesting a $5,000 cash bond in this case due to the nature of the charges. There's pretty significant amounts of narcotics involved in this case. The state is also requesting the conditions of no alcohol and no drugs. And I don't think there's any no contacts for this one.
There's a Sierra Judd. They're not asking for that.
I'm trying to find where she was mentioned. Oh, the driver. I do think no contact with her would be appropriate. Thank you.
All right, thank you. Mr. Copeland?
Your Honor, I would ask the court for a $1,000 cash bond. In this case, Mr. Phillips has ties to the community. He was born in Racine. He's currently living in Racine. Right now, he's on a PO hold. At this point, we're not sure about whether he's going through revocation proceedings. I understand the state's argument and what the allegations are alleging. In reading the criminal complaint, it doesn't appear that there's an allegation that a firearm was recovered, which a lot of times in these cases, in my experience, have been alleged along with a possession with intent to deliver. So given that, I think that's one mitigating circumstance. In this case, Mr. Phillips is looking for work. I'm not aware of any missed court appearances, but given those reasons, I would ask the court for a $1,000 cash bond.
All right, thank you, Mr. Copeland. Court has reviewed this criminal complaint and understands that these are allegations at this juncture. They're very serious. They involve a significant amount of illegal substances as alleged, and as alleged to attempted to deal these substances. Court believes there's a reasonable basis to believe that a cash bond is necessary to assure this defendant's appearance in court. It's going to enter a $2,500 cash bond. Mr. Phillips, conditions of bond, sir, you're to have no contact with Sierra Judd, C-I-A-R-A Judd, J-U-D-D, that you not possess alcoholic beverages or consume those alcoholic beverages, that you not possess or consume non-prescribed drugs or medications. Must appear in court every time if released in Kenosha County and may not commit further crimes while you're out on bond. You understand all those conditions, sir?
Mm-hmm. Yes, sir.
All right, thank you, sir.
Preliminary hearing. July 1st at 11 a.m. Thank you.
Yeah, no contact.
Yes.
All right, we'll call the matter of the state of Wisconsin versus Terrace D. Williams, 20 CM 735. Appearances, please.
The state appears by Carly McNeil.
Attorney Brett Copeland appears by video Zoom conference on behalf of Terrace Williams, who also appears in person and in custody. Your Honor, we do have a copy of the criminal complaint, and Mr. Williams is aware of the associated charges and maximum penalties. We waive a reading, reserve right to make jurisdictional objections and other objections, the right to a jury trial. We enter pleas of not guilty on all counts.
All right, thank you. Mr. Copeland, do we have an address for Mr. Williams?
So, Your Honor, I can update the court with the address of 4100 28th Avenue,
Department 1. I'm sorry.
All right, thank you.
Sorry.
It's all right. All right, you get that, Madam Clerk? All right, great, thank you. All righty, go ahead then. You've entered not guilty, please. Is that correct, Mr. Cope?
Yes.
All right, not guilty, please, and noted and entered for the record. Ms. McNeil as to bond.
The state is requesting a $500 cash bond in this case, as the defendant was already released on bond at the time of this offense. The defendant does have a prior record. He has been to prison before for 2 burglary convictions. One was in 2005, one was in 2010. In 2019, the defendant had a ticket for resisting or obstructing an officer, and then the defendant has older convictions predating 2010. The state is asking for the condition of no weapons.
All right, thank you. What's the status of the case? I guess this had been set in March. It's obviously still pending?
It is still pending.
Okay.
I can try to find a new court date if you would like me to look that up.
The next court date is July 21st.
There we have it. Thank you. All right, Mr. Copeland.
Your Honor, Mr. Williams is asking for the court to impose a signature bond in this case from the state's iteration of the criminal history. It appears that it may be a little dated, the most recent one being a 2015 case. I'm not aware of any missed court appearances. Mr. Williams does have secure employment at a temp service agency, and actually he starts work at 2:30 today and at Labor Solutions, and he believes that he would still be able to secure that employment if he can be released today. He is indigent. He cannot post any kind of cash to secure his release. In reading the criminal complaint, albeit that a gun was allegedly in this case, a BB gun. However, I don't believe that there was any rounds that were actually in the chamber of the firearm other than a CO2. So given that, I think that's one mitigating circumstance. In the criminal complaint, all that being said, I would ask the court to impose a signature bond.
All right, thank you, Mr. Copeland. Well, courts reviewed this criminal complaint, understands these are allegations, they're serious allegations with respect to the weapon being alleged to have been brandished and forcing an individual, at least one caller, to call regarding his gun being pulled out allegedly by this defendant. Court again believes there's the concern is when you're out on bond and then allegation here occurs as of this nature, that issue with returning to court or following bond conditions, court's going to believe there's a reasonable basis to believe that some cash is a cash bond is necessary to assure the defendant's appearance in court. Court's going to impose a $300 cash bond. Mr. Williams, conditions of bond are you not to possess any weapons and must appear in court every time when required if released, not commit any further crimes while you're out on bond. You understand? Yes, sir.
I just started work this week and I wouldn't be able to raise it $300 at all. But if I could go back to work and I could pay a fine or something for wasting the court's time, I can't.
I don't want you to make any statement against your interest. You're presumed innocent at this point, sir. You know,
I can't.
Fine or something is.
I can't afford a cash bond at all. It's just myself working, and I just started my job this week.
I understand, sir. I'm not. I believe there's an issue when someone's out on bond, and then they allegedly commit a crime again. That there's an issue with following court orders and returning to court as well. So that's why I'm going to continue with the $300 cash bond and those conditions, sir. At this point.
Can I ask you a question, sir?
Mr. Jones, Mr. Williams, Mr. Jones will speak with you after today, okay?
It's probably better if you talk to your lawyer about these things because you may make a mistake and make a statement against your legal interest here, and it's all being recorded.
Okay, with your other case, pretrial conference on July 21st at 8:30. Thank you.
Am I going into breakout room number 2?
You can go back there, yes.
Okay.
Okay, Mr. Russell is next.
Any rounds that were active in the chamber of the firearm other than a single two.
All right, and Mr. Jones, are you here for Mr. Russell?
I am, Your Honor.
All right, thank you. You're frozen at this point. Are you okay now? Let's see.
I can hear everyone and I can see you all just fine. Although there were some connection issues when I was speaking. Fine.
Yeah, Mr. Jones, I think what I'm going to have you do is actually log off of Zoom and then
Sure.
log back on right away and see if that fixes those issues.
Okay, I will
Okay.
do so in just a moment.
Sure, thank you. So to everyone else, we'll just wait till he comes back.
Yeah, I saw.
Okay, can you hear us and see us, Mr. Jones?
I can.
Yeah, nope, it's no better. Is there maybe a different office that you can try?
As long as everyone.
Yeah, we can't hear a word you're saying right now.
Sure. Move to.
Yep, nope.
All right. I will log back off then.
Okay. Hey, you're moving now. That's better.
Okay.
Perfect. Thank you.
All right, we'll call the matter of the state of Wisconsin versus Craig E. Russell Jr. It's 20 CF 692. Appearances, please.
It appears by Emily Trigg and District Attorney Mike Gravely.
Craig Russell appears through Zoom with Counsel Matthew Jones and waives the right to appear in person.
All right, again, the court has been making findings, and including this hearing, that good cause exists to hold this hearing via the Zoom application. Again, based on the coronavirus pandemic, orders entered by the Supreme Court for the state of Wisconsin and the Circuit Court for Kenosha County, and barring objection from counsel or the defendant. All right, Mr. Jones, did you receive a copy of the criminal complaint?
We have received a copy. We waive it. We acknowledge receipt, waive its reading, and request a preliminary hearing date.
All right, thank you. A request for preliminary hearing is noted and entered. As to bond, who will be arguing bond, Ms. Trigg?
I will, Commissioner.
All right, you may go then, please.
Thank you. And Lakeisha Jenkins is also appearing here today. She is the mother of Keyshawn, and I believe she wished to address the court for the purposes of.
Okay, I'd first like to listen to, I want to hear the arguments, and then I'll talk to mother of the victim, okay?
Sure, thank you. I just didn't want to forget.
Sure.
Your Honor, I believe $1 million bond in this case is appropriate. The defendant currently has charges pending before Judge Wagner. He has a $15,000 bond in that case that he has not yet posted. That case involves a firearm that was found in his vehicle, as well as some marijuana, and then he made some threats to law enforcement officers after he was arrested. As far as his prior criminal record, he has felony convictions from the state of Illinois and the one listed here from Kenosha in the criminal complaint. And I think the facts of this case warrant a significant bond as well. I should say, obviously, he's facing the highest penalty in this state with this charge. The facts of this case are that Keyshawn Jenkins was, his battery had died in his car. He was trying to move it to a place where that it could be jumped. Earlier in the day, there had been an altercation at a restaurant in the parking lot that was physical in nature. It involved Mr. Jenkins, and it also involved the defendant and some of his associates. So the way that the defendant tried to handle that situation was to arm himself, find Keyshawn Jenkins, and then shoot him on the street. There are the witnesses, I would say on behalf of the defendant, I believe gave statements that were untruthful, that covered for him, that it came out later through phone records and even by statements that they later gave that did have the defendant in Kenosha at the time where prior statements had not. There's video evidence of a car that the mother of the defendant's child indicates does look like his vehicle and does look like that he was involved in the shooting. There are phone records that that are suspicious and I think are can lead one to believe the defendant's guilt in this case. He's searching himself just hours after the shooting. He's searching the Kenosha News. None of those searches ever occur at any other time during his phone. I won't rehash every fact in the criminal complaint, but I think my point is that there are witness statements and there's corroborating physical evidence as far as video and phone information. I believe it's also significant that the two shots that hit Mr. Jenkins were from the back. The one in his arm went from back to front, and the one to his back obviously was in his back and then located later in his neck. And it also had a back to front motion indicating to me that Mr. Jenkins was trying to run away from the situation, which is also what witnesses describe. So given the record, the penalty here, the fact that there there's a pending gun offense, although it postdates this, I do believe $1 million cash bond is appropriate. There are a number of no contacts I would request. I don't know if the court would like me to cite them orally or just reference the discovery demand.
I do have a copy of what's referred to as a discovery demand. If this is the document with the, where I've circled below there, are these the individuals that you're going to ask no contact for?
Yes.
I do believe we do have to place that on the record though. So if you want to just go through that, please.
Sure. The individuals I am asking the Court to impose no contact orders with are Lakeisha Jenkins, Robin Leafblad, Kiara Hodges. In the criminal complaint, she's referenced as Clark, but it was discovered that her name is actually Kiara Hodges, Chiquita Jenkins, Charles Zay Johnson, Charles Chuck Johnson, Joquan Scott, Jayshawn Williams, Alexandra Luckett, Marcel Barnes, Taiwan Lott, Fred Lott, Devin Bazell Price, Shagal Jameson, Latanya Mace, and Jeremy Tops. I would also request that the defendant be ordered not to possess any weapons. Thank you.
All right, thank you very much. Mr. Jones, on the criminal complaint, do we have a correct address for Mr. Russell?
Yes, Your Honor.
All right, thank you very much. You may proceed.
Thank you. We are asking for a reasonable cash bond on this matter. We do recognize that cash is likely going to be necessary given the seriousness of the allegations. We do believe that $1 million is excessive to ensure Mr. Russell's appearance in court, particularly since he's been unable to post the $15,000 bond in his other case. I don't think there's any concern that he's going to post bond or be out on the street if that is the state's concern. As far as non-monetary conditions, we have no objections except to Robin Leafblad, as Miss Leafblad is Mr. Russell's fiance, and they do have children in common. We would ask that they be allowed to have contact, maybe no discussion of the case. Any contact they would have would very likely be while Mr. Russell is in custody, whether that's some sort of modified in-person visitation or if it's through the phone. I'm sure the state will be very diligently looking and reading through Mr. Russell's phone conversations. So I think that any concern regarding tampering evidence or intimidation of witnesses, the state would be able to identify that quite quickly. Otherwise, as to the actual monetary amount for bond, I would note that Mr. Russell has 6 children. As I said, he has his fiance, Robin. He also has his mother who he is in close contact with. He's been in custody since March, as I indicated. I would note that the possession of a firearm THC offense is currently set for trial. It has not been adjudicated, so those are also, at this point, only allegations. He has never missed a court date, as far as we are aware. Otherwise, we have no objection to the other non-monetary conditions. We do think that a lower cash bond, but likely a significant cash bond is necessary, and we would ask for a preliminary hearing date.
All right, thank you, Mr. Jones. Now this is to, ma'am, do you have something you wish to tell the court regarding bond? She's on mute at this point. Okay, ma'am, go ahead.
Yes, I think he need the highest bond possible, a cash bond, because I don't think he need to be able to walk the street because of what he did. So I think he need the highest bond possible.
All right, what is your name, ma'am, just so for the record? I'm sorry?
Lakeisha Jenkins.
All right, thank you very much. Okay, have you said everything you wanted to say?
Yes, sir.
All right, thank you, ma'am. All right, well, the court has reviewed this criminal complaint, understands these are allegations at this juncture. Nonetheless, they are the most serious. First-degree intentional homicide, use of a dangerous weapon, incredible amount of exposure. And as such, this court believes that their exposure is so significant that could lead, if conviction occurs, would lead to potential life imprisonment. And as such, the court believes that that would make Mr. Russell an extreme flight risk with respect to being released on this matter. Therefore, the court is going to impose, believe it reasonable and necessary to impose a very significant cash bond necessary to assure the defendant's appearance in court of $1 million. Mr. Russell, conditions of bond are in this case that you may not possess any weapons. I understand also that you're a resident of the state of Illinois, and that was further taken into account of this court as well with respect to the issue of the flight risk. I may possess no weapons of any type, including and especially firearms if released. I do take into account his also it's post dated, but there is a allegation of a gun offense, gun related offense. And again, understands that's an allegation as well. Further conditions, sir, that you have no contact with the following individuals: Lakeisha Jenkins, Robin Leafblad, Kiara Hodges, Chiquita Jenkins, Charles Zay Johnson, Charles Chuck Johnson, Jokan Scott, Deshaun Williams, Alexandra Luckett, Marcel Barnes, Taiwan Lott, Fred Lott, Devon Bizzle Price, Chagall Jameson, Latanya Mace, or Jeremy Tops. What that means, sir, is no contact in any form, any location, any means, including electronic communications. Also, if you're released, sir, you must appear in court every time when required and not commit further crimes while out on bond. You understand all of those conditions, sir? All right, thank you, sir.
Your Honor, before Madam Clerk gives a date, I would note that Mr. Russell is eligible for a public defender. However, I believe that he might be a conflict with our office to represent him in any further capacity than this. I did not think to ask Mr. Russell if he would be willing to consider waiving time limits for a preliminary hearing, but that might be necessary, as I don't know if we'll be able to get him an attorney in time.
You wish me to ask Mr. Russell?
If the court could or I could, it's
Well,
up to
if you want to go back to a breakout with him, or do you want to ask him right now? Go ahead if you want.
I think if we do it right now, Mr. Russell, like I said before, our office is going to try to appoint a private attorney for you. Our office will be paying for that attorney. We're going to try to get you one as soon as possible. You have the right to have a preliminary hearing within 20 days of today's date. It's likely that we might not be able to get an attorney for you in that time frame. If you give the court permission, the court can waive that time limit. They'll schedule a preliminary hearing later on. It would mean that you'd have a better chance of having an attorney there for that hearing.
Mr. Jones, I'm sorry to interrupt, but you mentioned 20 days. I believe it's 10 days.
Oh, excuse me. Yes, it is. I misspoke. I apologize.
That's fine.
Yes, I was lucky. Yes, it is. I'm sorry. It's 10 days. You have the right to have that within 10 days, which would functionally be 2 weeks from today's date. It's unlikely we'll have an attorney appointed for you. So that what would happen is if you don't have a preliminary hearing, you would either have to, if you don't have an attorney for your prelim, you would either have to do that on your own, or we would have to get another status date for you to appoint an attorney for you, which is what we would recommend. It would be a good idea, I think, to toll time limits or waive time limits on your preliminary hearing, but that's your decision.
All right, sir. I just have a few questions for you. Did you hear everything that your attorney, Mr. Jones, just indicated to you in regards to the scheduling or calendaring of a preliminary hearing?
Yeah,
Did you understand everything Mr. Jones just indicated to you?
yeah.
All right. Now you have a choice. You can either waive time, allow this court to toll time to schedule your preliminary hearing farther out than the 10-day statutory limit, because you're entitled to a preliminary hearing to be held within 10 days of your initial appearance. You understand that?
Mhm.
Yes?
Yeah.
Okay. You also have the right to waive time and ask this court to toll time to schedule your preliminary hearing farther out beyond the 10 days, in this case for good cause, to ensure that you have an attorney appearing on your behalf at the preliminary hearing. You understand?
Mhm.
Okay, what do you wish to do today, sir?
Would I be able to find one for myself also?
Of course. I mean, that's always an option that you obviously could employ, if you will, or hire, retain, whatever word you wish to use, your own counsel to represent you. Yes, you could. And even if one attorney begins to represent you, could always hire your own attorney if you wish to do so as well, to either assist that attorney or to step in the place of that attorney. That's up to you, sir. But what I want to know is, what Mr. Jones indicated to you is you said you understood that it's unlikely that within the 10-day timeframe, the state public defender's office will be able to secure an attorney or appoint an attorney to represent you. So it's up to you. You can either waive time and have the preliminary hearing scheduled farther beyond the 10-day statutory limit, or you may say decline to do that and we'll schedule your preliminary hearing within the 10-day.
I decline. I'll decline.
You want to have the preliminary, you don't wish to waive time, correct?
No.
All right. I want to make sure that, because I asked you correct and you said, no, that was my fault. Do you wish to waive time or not?
Yeah, I'll like it in 10 days. So I would like it in 10 days.
All right, so then you're not waiving time, then we'll calendar your matter for preliminary hearing within 10 days from today, all right?
And Your Honor, if I could be heard, I'm going to be out of town on after July 4th. So I'm asking the court to do this late next week. So, and I'll make myself available on whatever day late next week in the morning you wish to schedule it if you can.
All right, thank you, we'll check.
The 10 days is up on July 2nd with our calendar. So latest I can do is July 2nd at 11 a.m.
Ms. Trigg?
That works. I was just going to request a date on either Tuesday or Thursday. So the
All
second
right.
works. Thank you.
Yeah, the second is fine.
Mr. Gray?
I will make it clear to our office that we need to appoint someone as soon as possible.
All right, thank you, Mr. Jones.
Thank you.
Thank you.
All right, we'll see you then, sir. Ready for Nelson?
No, I'm not.
Mr. Jones, do you have to go back to the breakout room?
I assume there are more people. I don't know the
Oh, okay.
steps.
Okay, sure. Let me assign you because I know you've had to log off. There you go. Now you should be able to go back to number 1.
All righty, I will call, I have two files, the state of Wisconsin versus Cardell A. Edwards. I have 20 CF 401 and 20 CM 737 appearances.
The state appears by Carly McNeil.
Attorney Brett Copeland appears by video Zoom conference on behalf of Cardell Edwards. Your Honor, Mr. Edwards has received copies of both criminal complaints, understands the charges and penalties, a waiver of reading, reserve rights to make jurisdictional objections, and other objections, right to a jury trial. In regards to the 20 CM 737 file, we enter a plea of not guilty on that count. And then with the 20 CF 401, we'd ask for a preliminary hearing date.
All right, thank you. I also have two TR files that I'll order to trail the CM file. So would you want me to enter pleas on behalf of Mr. Edwards at this point, Mr. Copeland?
Not guilty plea, yes.
Okay, yeah, that's 20 TR 3769, 20 TR 3770. Court will enter not guilty pleas on behalf of Mr. Edwards. And those are, I believe, Kenosha County versus Cardell Alvino Edwards. So not guilty pleas are noted with respect to both of the TR files. I'll order that the TR files trail the CM file. All right, well, let's take up first then the CM file here. We'll take up that issue. Again, not guilty plea has been entered with respect to the criminal complaint. So as to bond, then Ms. McNeil.
The state is requesting a $500 cash bond in that case, as the defendant gave a false name. The defendant does have a prior criminal history. He is charged as a repeater with his most recent offense, which is out of Arkansas. And then it looks like he has an older offense out of Arkansas that is from 2003 for a domestic violence battery and residential burglary. So because of the out-of-state connections, I think cash is appropriate, even though this is a misdemeanor charge. And I am requesting no contact with Angel Cervantes.
All right, thank you, Mr. Copeland.
Your Honor, in regards to the non-monetary bond condition, Mr. Edwards does not have an objection. For this file, we'd be asking for the court to fashion a signature bond. Mr. Edwards does have a residence here in Kenosha. He does have ties to the community. He has 4 minor children. I'm not aware of missed court appearances. So for this case, I would ask for a signature bond.
All right, thank you, Mr. Copeland. I do see, and these are allegations, court's well aware of that, but according to the complaint, there was a felony warrant. I guess they're talking here issued or through the Pleasant Prairie Police Department, and then the probation and parole warrant out of Arkansas. So do we know what's the story on that, Ms. McNeil, just briefly? I know you touched upon it.
You're wondering about the status of the probation and parole warrant?
Right.
I'm not sure what is occurring with that. There's a possibility that there will be an extradition on that, but I'm not sure what's happening with it yet.
All right. And what about this reported issue out of Pleasant Prairie?
You know, I thought they were referring to the felony file that we're going to hear next,
Okay.
which occurred on March 14th of 2020.
Okay, that's fine.
I was told by the court officer that there's a pre-signed waiver on the extradition for Arkansas.
Oh, okay. All right. Okay. All right. Thank you. Thank you for everyone for answering those questions. All right. Well, the court's reviewed this complaint and understands that these are allegations. Nonetheless, with the issues, the warrants that were pending, court believes that there's a reasonable basis to the cash bonds necessary to assure the defendant's appearance in court. Court's going to impose a $500 cash bond. Mr. Edwards, conditions of bond, though, in this file, do not to have any contact in any form with an Angel Cervantes, in any form, anytime, any method. And then if you're released, you must appear in court every time when required, not commit further crimes or you're out on bond. Understand? Okay. You have to say it out loud because we're recording.
Yes, sir.
Thank you, sir. All right. Next, I have, we'll hear the matter of This one here is the 20 CF 401. There was an arrest warrant issued in April in the amount of $15,000. I'll vacate the arrest warrant. As to bond, Ms. McNeil.
The state is requesting a $10,000 cash bond in that case. The charges are very serious, and as we spoke about in the prior case, the defendant does have the connections out of state to Arkansas. The state is requesting no contact with the following people: Angel Cervantes, Christy Gonzalez, and Nadine Canaday, or their residences.
All right, thank you. Mr. Copeland.
Your Honor, Mr. Edwards does not have an objection to the non-monetary bond conditions that were requested by the state. However, he would be asking for a cash bond between the amount of $1,500 to $2,000, along with the other case. He would have to post up to $2,500. Of that is what the court does fashion. I rest on my prior arguments in the last case that was called. He does live here in Kenosha. He does have 4 minor children and needs the support. I would ask for a $1,500 to $2,000 cash bond, as I would secure his future court appearances.
All right, thank you, Mr. Copeland. Court has reviewed the criminal complaint, understands, again, these are allegations. These are obviously more serious in nature, but nonetheless remain as allegations. Court believes that the cash bond is necessary to assure the defendant's appearance in court for the reasons previously stated, with the ties to the state of Arkansas, the issues of the warrants and the warrant issued in this case. Court's going to impose a $2,000 cash bond. Mr. Edwards, conditions of bond in this file are: must appear in court when required, not commit further crimes while you're out on bond, no contact with the following 3 people. I have to say it on the record, sir: Angel M. Cervantes, Christy Gonzalez, or Nadine L. Canaday, C-A-N-A-D-Y. Now, that's no contact in person, through any type of means, any location, any type of contact method. Okay, sir?
Yes, sir.
Thank you, sir.
Preliminary hearing, July 1st at 11:15. Thank you.
Hey, about that extradition waiver, I ain't even seen none of it.
We have to have it here. I think you're going to have to, if it's waived, there maybe an issue. Okay, so the state of Arkansas is going to have to make arrangements, I would imagine. So we don't have any knowledge of that or information that can assist you with that right now. You may want to talk to one of your attorneys in regards to that, okay?
And then
All right, we'll call the matter of the state of Wisconsin versus Derek Robert Nelson, 20 CF 689. Appearances, please.
The state appears by Carly McNeil.
Attorney Brett Copeland appears by video Zoom conference on behalf of Derek Nelson, who appears in person and in custody. Your Honor, Mr. Nelson does have a copy of the criminal complaint and understands the associated charges and penalties therein. We waive a reading, reserve rights for jurisdictional objections and other objections, and the right to a jury trial. We'd ask for a preliminary hearing date.
All right, thank you. Request for preliminary hearing is noted and entered for the record. Ms. McNeil, as to bond.
The state is requesting a $50,000 cash bond in this case. I am not aware that the defendant has any prior criminal record, but the nature of these charges alone is extraordinarily serious. And each of these charges carries a 3-year mandatory minimum sentence in terms of initial confinement, which is certainly a motive to not remain bond compliant and not appear in court. So while I understand that the defendant does not have a history, I think $50,000 will be necessary to secure his appearance. The state is requesting no contact be ordered with any child who is under the age of 18. And the state is also requesting a condition that the defendant not access the internet or use any device that is capable of accessing the internet. All
right, thank you, Ms. McNeil. Mr. Copeland.
Your Honor, Mr. Nelson would be requesting the court for a $2,000 cash bond. As the state indicated regarding a lack of criminal history, I'm also not aware of any criminal record in speaking with Mr. Nelson. I'm not even I'm not even aware if he was ever even been arrested before. It sounds like this is his first encounter with the criminal justice system. I'm not aware of any of his court appearances. He was working for a construction business. He's from Racine. He's been living here in Kenosha. He does have ties to our community. Is not living either beyond state lines. I think a $2,000 cash bond would be enough to secure and to incentivize future court appearances.
All right, thank you, Mr. Copeland. Court has reviewed this complaint and once again understands that at this juncture, there are allegations. Nonetheless, they are extremely serious. 10 counts of possession of child pornography. They do carry presumptive minimum periods of incarceration if convictions occur of at least 3 years each, and which would place this for decades of initial confinement. That, as such, the exposure is very great. It would be, in this court's opinion, a risk to appear in court if released. A flight risk issue looms large, if you will, with respect to this type of exposure. And as such, court believes that a cash bond is necessary to assure the defendant's appearance in court. It's going to enter a $25,000 cash bond. Mr. Nelson, conditions of bond, sir, in this case are as follows. You're not to have any contact with children under the age of 18. Incidental contact may or may not be considered depending on the type of contact. But you, sir, no contact with children under the age of 18 as a non-monetary condition. Further, you're not to possess, if you're released, I assume there's been a report, Mr. Copeland, that your client operates a business. Is that correct?
He was working for a construction company, yes.
Oh, working for, okay. All right, because I was concerned about internet use for business, but I won't have to be worried about that now. I'm going to order, sir, that you not have any access to the internet nor possess any devices capable of accessing the internet. Now, there was discussion here, if I recall, in this complaint that if you're released, you reside with someone that more than likely will have internet access devices in the home. I'm not going to bar you from having those in your home. I'm barring you from possessing any such any electronic items or devices that are capable of accessing the internet. And you, sir, may not access the internet as non-monetary conditions. Do you understand? Okay. Also, you must appear in court every time when required in Kenosha County and not commit further crimes while you're out on bond. Do you understand all of those conditions, sir?
Yes.
All right. Thank you, sir. No, 25.
Preliminary hearing, July 1st at 8:15. Thank you.
Thank you.
Oh, no, that was the one I sent with the email in this morning, that that's a conflict, he's the conflict. And, he was going at 1 o'clock, and the other side was at 1 o'clock, so it was, what all happened. Yeah. Oh, maybe I missed something.
Mr. Copeland, I only have the one female left and then someone else who's Mr. Jones's client. So we should be done with you. Have a good weekend. Thank you.
All righty, we'll call the matter of the state of Wisconsin. Oh, sorry.
Sorry, technical difficulties.
We have to see, we have to,
just have to take it out. We don't leave the meeting. But where it says leave in the corner, just be sure you don't leave.
there you go. Thank you. All good. All right, now I'll call the matter of the state of Wisconsin versus Nicole E. Newnam, 20 CF 690, as well as Kenosha County versus Nicole E. Newnam. And that's 20 TR 3772 and 3773. Appearances, please.
The state appears by Carly McNeil.
Ms. Nicole Newnam appears through Zoom with counsel Matthew Jones. She waives the right to appear in person. She has received a copy of the criminal complaint, as well as the associated charges and maximum penalties. We waive a reading of the complaint. We request a preliminary hearing and ask that the TRs be let trail.
All right, thank you. Request for preliminary hearing is noted and entered with respect to the CF file. I'll order the TR files trail without having to have please entered at this point. All right. As to bond then, Ms. McNeil.
The state does not object to a signature bond in this case, as the defendant does not have a prior criminal history. The state is requesting the conditions of no alcohol, no controlled substances without a prescription, no drug paraphernalia, not to drive without a valid license. And the state is requesting no contact with the Marina Bar on Silver Lake Road, with Patricia Bridges, with Susan, last name spelled S-E-X-E, and with Erasto Gregorio Ortiz, or their residences.
All right, thank you. Mr. Jones?
Thank you, Your Honor. We agree with the state's position as to bond. I would note that Ms. McNeil is correct. Ms. Newnam does have no criminal history. I'd be happy to expand upon that if the court wants further argument as to the monetary portion of bond.
No, that's fine, Mr. Jones.
Thank you. For the non-monetary conditions, I would note that Ms. Newnam is, or at least was, employed by the Marina Bar. I don't know. We imagine that that position is no longer available to her. Regardless, there would likely be some issue of getting a final paycheck. If Ms. Newnam is able to keep working at Marina Bar and she would prefer to do so, we would ask that if that's the case, the court allows her to continue to be there for employment purposes. Similarly, we would ask that the court allow contact with Susan, last name S-E-X-E, only for employment purposes if she is able to keep that job. And finally, since that job would involve being around alcohol, we would ask that the no alcohol condition merely extend to consumption of alcohol, or at least allow possession for purposes of employment.
All right, thank you, Mr. Jones. Court's going to impose a $2,000 signature bond. Ms. Newnam, conditions of bond are going to be that you yourself may not possess, or excuse me, you may not consume alcoholic beverages. You may possess alcoholic beverages only for employment purposes during employment. Further, you may not possess or consume non-prescribed drugs or medications. If you have prescribed medications, you may take those, but only as prescribed. May not operate any motor vehicle without a valid driver's license. You must appear in court when required, not commit further crimes while you're out on bond. But at this point, I'm going to order that you not have contact in any form with a Patricia Bridges, a Susan Sexe, or an Erasta Gregorio Ortiz. That's Erasto Gregorio Gregorio-Ortiz, Ortiz. Now, I'm not gonna, if there's an issue with this employment issue I'm gonna order at this point, you're not to have contact to be on the premises of the Marina Bar. That check could be sent to you at your last known address, if that's an issue. But Mr. Jones, if that becomes an issue, this is gonna come back here for a preliminary hearing. You can address that issue again, if in fact it is at that point an issue. But otherwise, ma'am, as of right now, no contact in any form with any of those individuals at any location. And then no contact, or you may not be on the premises of the Marina Bar at this point. Do you understand all of those conditions?
Yes, sir.
Thank you very much.
Your Honor, would the court allow a third-party contact with Marina Bar if for no other reason than to see what it would require for her to get her payment or her paycheck, or see if they would mail it to her for like a 24-hour period?
Sure, that's fine. I'll tell you what we'll do. 24 hours after your release, you can send a third party to that bar, Marina Bar, to check on in terms of your employment status, and secondly, to check on whether or not they can secure or have mailed to you a last paycheck.
Preliminary hearing, July the 16th. That's July 1/6 at 9:30.
Thank you.
Thank you.
And Ms. Noonan, that will be on your bond. So when you sign your bond, it will tell you when to appear.
Yeah.
Thank you. And then, Mr. Jones, we just have your last one from this morning, Mr. Sloan.
Oh, perfect. I was going to inform the court he had called me and accidentally did not leave the right callback number. So perfect.
All right, well, let me call the case then, okay? I'll call the state of Wisconsin versus Tariq T. Sloan, 20 CF 334. Appearances, please.
State appears by Carly McNeil.
Mr. Jones?
Tariq Sloan appears through the phone with counsel Matthew Jones.
All right, I understand he contacted you, didn't leave a correct phone number, or for whatever reason. I'm gonna, and at this point, I'm not staying this bench warrant any further, but again, if you do have contact with him, you can contact our court to calendar an appearance, okay, Mr. Jones?
Understand. If I may clarify, Your Honor, because of the work from home order, my office phone is forwarded to a Google Voice number on my cell phone. So he said, call me back on this number. Unfortunately, because of the Google Voice number, the way it's forwarded, it showed up on my phone just as my office number. So he was not aware of that. That is just a function of how my call forwarding is set up.
All right, that's fine for the record, but again, the bench warrant is now in full force and effect. And again, you may schedule a voluntary surrender appearance if or when you have contact again with Mr. Sloan, all right?
And that was $1,500 cash.
Correct, right.
And then the 1,500 that was posted.
I'm not going to take a position on that at this point.
Okay. Thank you.
All right, thank
Have
you.
a good
everyone.
weekend.